I'll just introduce myself in a bit more detail. As I mentioned, my name's Julian Hackenberg. I'll be running today's session. I'm the Australian HR Manager for MyHR. And MyHR provides HR advice and support to clients who are predominantly small and medium-sized businesses. And my role is to provide HR advice to support our clients in Australia. Before we kick off the session in a bit more detail, just a bit of housekeeping. Today's session is being recorded. So the recording will be available afterwards on the MyHR website. But also any questions will be recorded as well and available afterwards. So please, use only details that you're comfortable sharing and submit any sort of question anonymously. So if there are questions, I can answer those towards the end of today's session. And you can submit those through the chat function as we go, and I'll just sort of monitor that, but likely get to those towards the end of the session today. But feel free if something comes to mind at all, just shoot a message within the chat, and hopefully I can provide a response. So today's session. So basically, today will just be, I suppose, a brief introduction to casual conversion under the National Employment Standards. So what we'll cover is we'll go through an overview of the casual conversion provisions that were included as part of the Fair Work Act Amendment announced in March 2021. And we'll cover that through a bit of context and background and a bit of a refresher of the actual requirements. And also, while we're talking about it now in September, there was a transition period announced for businesses that engage 15 employees or more. And that transition period was 6 months, and it's coming to an end. So there are certain things that some employers who engage casual employees need to do by the 27th of September. We'll explore the impact of the change and what it means for employers and employees. We'll look at previous award requirements, how these changes will interact with modern awards. And we'll look at the different requirements for small and larger businesses, and the actions that I mentioned some businesses will need to take by the 27th of September. We'll also look at what's known as reasonable grounds for refusing or not offering casual conversion. And we'll also look at some other things around what the ongoing obligations and requirements might be for some employers. If an employee declines an offer, do you have to re-offer down the track? Can the employee request casual conversion to full-time or part-time at a later date? Those sorts of things I often hear from clients around this sort of thing. So I think in summary, a lot's happened since March and now, and we thought it'd be a good refresher. But hopefully, as a takeaway from today's session, you'll have a better understanding of your obligations around engaging casual employees and the pathway that casual employees now have towards permanent employment, and also what you'll need to do in order to comply with those requirements under the NES as well. So initially, just an overview of the casual conversion provisions and the Fair Work Act Amendment announced in March. So there's a bit of sort of context and a reminder. There were a number of announcements made earlier in the year around casual employment. One was having a more concrete definition of casual employees. And up until that point, the definition of a casual employee was quite grey, and it sort of led to some confusion and also some cases where employees had claimed that they'd been misclassified. So what the government sought to do was have a more clear definition of casual employment, and that is no firm advanced commitment to continuing and indefinite work. And the employee accepts that and they're engaged on that basis. And so this means the determination of whether an employee is casual is made at the outset of their employment. So it occurs at the offer and acceptance of employment. There was also an introduction of an offsetting arrangement, which allowed employers to use the casual loading that casual employees receive. So using amounts paid to the casual loading to offset any claim that an employee makes in the future for entitlements under the National Employment Standards. So casual employees, of course, do not receive paid annual leave or personal leave, don't receive paid notice or redundancy pay or anything like that. They receive a 25% casual loading, which is paid to them instead of those other entitlements. Again, in terms of potential claims of misclassifying, it was determined that with these amendments that employers could use the amount paid as casual loading to offset any potential claim that employees made for those entitlements if they were to argue that they were misclassified. In addition to that, there was a requirement that employers issue casual employees a document known as the Casual Employment Information Statement. Now, you're probably aware of the Fair Work Information Statement that's been around since the Fair Work Act came in place, basically. This is a document specifically for casual employees. And so small employers have had to issue that document to employees from 27 March this year. For larger employers engaging 15 or more employees, as part of that transition period, they actually haven't had to issue that document until the end of the transition period, which is the 27th of September, so coming up. And of course, all new employees should receive, new casual employees should receive that document. In terms of specifically around casual conversion, what the amendment sought to do was also just have one distinct process around casual conversion. Previously, casual conversion rights were in modern awards and enterprise agreements as well, where that was relevant. Usually the onus was on the employee to request casual conversion. In fact, the onus was on the employee to request casual conversion. And there's also inconsistencies between awards. So some awards would have a casual conversion right after 6 months, or most awards after 12 months. And then if a casual employee wasn't covered by an award, then there was no casual conversion provision as well. It wasn't a straightforward process either, so it's quite sort of long-winded. If anyone's seen these clauses within modern awards, they're quite long-winded and not particularly easy to read and understand what the actual requirements were. So there was an attempt, I suppose, to really just sort of simplify the process a bit. Now, offers in request for casual conversion are included within National Employment Standards. The NES applies to all employees. It's consistent and relatively straightforward. However, there are process steps and documentation requirements that employers need to undertake to demonstrate that they're complying with this requirement. And the onus is on employers if it is a larger business. So other than small businesses, so less than 15 employees, employers must offer casual conversion to eligible employees. And as I mentioned, there was a transition period put in place. So for those larger businesses, there was a 6-month transition period from March until 27th of September, for which businesses could prepare and make assessments around eligibility of their casual employees. So in terms of the impact of the change and what it means, awards still have casual conversion provisions within them. The Fair Work Commission is in the process of reviewing award terms around casual conversion and really to identify inconsistencies or difficulties around casual conversion terms. And what they're looking to do is really just sort of standardise the process across the board. And so they're due to report back or complete their review by the 27th of September. As it stands, there are still requirements under modern awards for employees to, or still the ability for employees under modern awards to request casual conversion, and certain requirements for employers to notify employees of their rights or their ability to request casual conversion under those awards. Under these changes, as I've sort of alluded to a couple of times, there are two different requirements depending on the size of the business. So for smaller businesses, it is more straightforward from the employer's standpoint. So small business employers employers who engage fewer than 15 employees. And so when determining the size of the business, you really need to factor in the number of employees and employees of associated entities. Importantly as well, casual employees are generally not included in that assessment unless they're engaged on a regular and systematic basis. So that's important to know. And if you are a small business employer, then you don't need to proactively offer casual conversion. So you don't need to offer it at any point or have the paperwork or the process around it. However, employees have the right to request casual conversion to permanent employment if they've been employed for 12 months. And this right to request came into effect from the 27th of March. And employers need to respond in writing to those requests within 21 days, detailing either an acceptance of that request or the reasons for not accepting a request. And if the employer refuses the request, then they need to advise the employee in writing of the reasons why. And look, really, the only reasons for that could be based on reasonable grounds, which we'll cover off a little bit later, or if the employee is not eligible. So if they haven't worked a certain pattern of hours in order to qualify. So the qualification requirements are 12 months employment, and the last 6 months of that 12 months working a regular pattern of hours, and the capability or the capacity to work that regular pattern of hours going forward. So that's small employers. So there's nothing to do in terms of proactively offering casual conversion to employees if you're a small business. If you engage 15 or more employees, then there is a requirement, and there's a requirement to assess their casual employees who were employed before 27 March 2021 for their eligibility to be offered permanent employment. This assessment must occur by 27 September 2021. And where an employee is eligible for conversion, they must be offered permanent employment in writing within 21 days. If an employee is not eligible, because, for example, they haven't worked a regular pattern of hours for the past 6 months, then you actually need to notify them in writing of their ineligibility and the reasons why they're not eligible. If an employee is eligible, they've worked for the business for 12 months and have worked a regular pattern of hours for the last 6 months, and you're not wishing to offer them permanent employment, that must be on reasonable grounds, and you need to detail those reasonable grounds to the employee also in writing. So that assessment and the notification, so that assessment needs to occur by the 27th of September, and that assessment involves determining whether the employee is eligible for to be offered conversion to full-time or part-time employment. And where they are eligible, then an offer needs to be made to the employee within 21 days. If they're not eligible, then that needs to be put to the employee in writing within 21 days also. And then moving forward, this offer and or notification of ineligibility must also be made to any casual employee who's employed for 12 months also. So that's a bit of a summary of the requirements and the different requirements for small and medium-sized businesses. If we focus a little bit more on the larger business front and the actual requirements there, because that is more pressing, just to really sort of ramp that home, by the 27th of September 2021, which is the conclusion of the 6-month transition period, employers with 15 or more employees must perform that assessment to determine whether existing casual employees are eligible to be offered casual conversion to permanent employment. And that is for employees who were employed as casuals before 27 March 2021, have been employed by the business for 12 months or more. They've had a regular pattern of hours on an ongoing basis for at least the past 6 months. And so that is, the employees worked relatively consistent hours for the past 6 months overall, which they could have worked or could continue to work as a full-time or part-time employee. And the fourth is the ability to continue to work those hours as a full-time or part-time employee without significant change. Secondly, where a casual employee is eligible to be offered casual conversion, they must be offered the conversion of full or part-time employment in writing and within 21 days. Where an employee is not eligible based on reasonable grounds, or they have not worked a regular pattern of hours within the last 6 months, then they also need to be advised of their ineligibility in writing within 21 days. And if a casual employee accepts an offer to convert, the employer needs to confirm that in writing to the employee within 21 days after their acceptance as well. So as you can see, there's a bit of process, a bit of documentation that needs to be undertaken with this change and with this process. I've mentioned reasonable grounds a couple of times, and so there are reasonable grounds for refusing a request for casual conversion to permanent employment, or for not offering permanent employment through casual conversion. Again, the distinction between smaller and larger businesses and the different obligations there. But there are reasonable grounds for not making an offer or refusing a request, and these reasonable grounds must be based on facts that are known or reasonably foreseeable. And so the reasonable grounds for deciding not to make an offer or declining an offer include: within the next 12 months, the employee's position won't exist. The employee's hours of work will significantly reduce. The employee's days or time to work will significantly change, and that can't be accommodated within the employee's available days or times for work. So there are further reasonable grounds, and that list is not exhaustive, so there could be other reasonable grounds for refusing also. But if I can sort of talk to a couple of those points, and again, the reasonable grounds must be based on facts that are known or reasonably foreseeable. So, for example, the employee's position won't exist. There might be a circumstance whereby, for restructuring purposes, or the business is going through change that it's aware of, and potentially the employee is aware of as well. And so, you may know in that case that 3 or 4 or 6 or 12 months or however long the employee's position won't exist, and you know that with pretty good certainty. And that may be reasonable grounds for not offering or refusing a request for casual conversion. Likewise, there may be a significant reduction in the hours that an employee may be required. So their work may be seasonal, or there might be a particular change to their section of the enterprise, which is maybe in decline or sort of in a reduction for the sort of needs for employees, or perhaps sort of technology introduction, meaning that there's less requirement for workers in that space. That might be another reason to say that within this time frame, we know with pretty good certainty that there will be a pretty strong reduction in hours, and potentially even this employee may not be engaged in a regular amount of hours going forward. So again, that might be they could be examples of reasonable grounds for not offering or refusing a request for casual conversion, but that needs to be based on facts that are known or reasonably foreseeable. I suppose it's worth pointing out that there are other issues. So the intention behind this, the introduction of the casual conversion rights, certainly not to it's to encourage greater permanent employment. I think it's identified that there's certainly a lot of casual employees who are working regular, systematic hours for businesses in Australia, right now, and it's to have a clear process in place for those employees if they want to become permanent employees of those businesses. So as an employer, you can't, under these amendments, terminate an employee or deliberately change their roster so that they don't meet the eligibility requirements. It's not in the nature of these changes. And it's also a workplace right. So employees are protected from adverse action, which could include termination or changes to their roster, in order to avoid them having access to this workplace right. I think it's also important to note that casual employees can have protections from unfair dismissal if they've worked a sufficient length of time and worked regular and systematic hours for businesses as well. So there are, of course, for this sort of stuff, there are other issues that could arise and things to be aware of. So that's been a bit of a summary of the change. But I suppose I just really want to talk to the ongoing obligations around casual conversion as well. And really, following the end of this transition period, it's not like the end of the transition period comes and you make your offers and you follow the process and then it goes away. There are ongoing requirements if you're engaging casual employees. And again, if you're a larger business, once the employee reaches that 12 months mark of service, then that's where we need to make the assessment. Has the employee, for the last 6 of the 12-month period, worked a regular pattern of hours on an ongoing basis? And what sort of information do we have to assess that in terms of rosters and that sort of stuff? Also determine whether there are reasonable grounds for the employer not to offer conversion. Are these basic facts? Do we know these for certain? Do we need to do any sort of further research or gather further information to properly make this assessment? And if the employee is eligible for conversion, and there aren't reasonable grounds, then an offer needs to be made within 21 days to either full-time or part-time employment, depending on the actual hours that they're working. So we may need to review the award that applies to assess what are the requirements around part-time employment versus full-time employment. Are there any specific hours that must be worked for part-time employees under this award? And based on the pattern of work, are they meeting that requirement accordingly? And if we assess that they are not eligible because they haven't worked a pattern of hours or there are reasonable grounds which we've gone through, then again we need to notify employees of that within 21 days of them completing 12 months of employment. One question with this is, if an employee declines an offer, do we need to offer it again? Can they request at a later date? Under the award system, it was the onus was on the employee, and if it didn't come to fruition and an employee converted to full-time or part-time employment, then there wasn't necessarily a case of it occurring again. With this, there's a residual right to request casual conversion. So an employer is obliged under the National Employment Standards to offer conversion once. So if you're a large employer, then you're obliged to offer it at that 12-month mark. However, an employee does also have a residual right to request casual conversion. So this allows the employee to request their employer to convert them to permanent employment after their initial conversion entitlement at 12 months. But an employee may not make the request if they've already requested conversion in the last 6 months. So An employee may reach the 12-month mark, request or be offered casual conversion, and that request may be denied, or the employee may even deny it themselves if they're offered by their employer. However, they can carry that right to request casual conversion at a later date. So in that case, they need to work through the 12 months before they can request it again, but they can request it again. So it's important to know that. Again, it's not like you do it at the 12-month mark and it goes away. There's potential that the employee could request it down the track. And you need to follow the same process around responding to requests within certain time frames, 21 days, and having the appropriate documentation, and so on and so forth. So there is that ongoing residual right for casual employees as well. All right, so look, that really concludes a lot of the content that we wanted to go through today. I suppose the main takeouts for this are, I think as employers, it's important to understand changes as they occur and how these impact on you and your business. These amendments were announced in March. A lot's happened between March and now, particularly in Sydney and Melbourne. It's likely that these changes sort of got lost along the way and forgotten about. But particularly if you engage 15 or more employees, there is a requirement for you to assess these casual employees' eligibility for casual conversion or conversion to full or part-time employment, and that needs to be done by the 27th of September. And where an employee is eligible, then an offer needs to be made within 21 days of that date. Where they're not eligible, there are process steps which involve notifying them in writing as well within 21 days. Ineligibility can only be for valid reasons, either based on reasonable grounds or they haven't worked a regular pattern of hours for the last 6 months. I think it's important as well to have those proactive steps in place, including having reminders, making sure that the appropriate documentation, the appropriate documentation to say, hey, these are the reasonable grounds, and then this is the information to support us making this decision. And the reminders to say, look, at this 12-month mark that we need to make this assessment, we also need to follow these process steps. So there's that element as well. The process steps are there. The process steps are there and they're important, and that's part of this whole thing is really ensuring that the business is able to demonstrate it's completed the process and documented the process also. And I think advice and support with this sort of stuff is always relevant and needed, particularly for smaller and medium-sized businesses, because it's not always clear what the requirements are. Sometimes it's just getting second opinion or advice and documentation, and that sort of thing as well. So look, I think we've got a couple of questions that have come through. So I might just read those out. So first one here says, probably stating the obvious, but if you offer casual conversion, the hourly rate would decrease to the award level for a part-timer, i.e. they lose the casual learning. Yes, that's correct. So if they're currently receiving the base award rate plus the casual loading, if they were to accept or request conversion to full part-time, then their rate would drop accordingly to the award rate without the casual loading. Another question: if the 12 months has passed and the offer has been made and they decline, does your obligation to offer again happen in another 12 months' time, or only the 12 months offer? This hasn't been clear in any communication. So sorry, I'll just read that again. So if the 12 has passed and the offer has been made and they decline, does your obligation to offer again happen in another 12 months? So you don't have a further obligation to offer. So you offer at the 12-month mark, and if they decline, then there's no requirement to come back around at the subsequent 12-month mark or any other point in the future. However, the employee does have that residual right to request. So the residual right wouldn't kick in until after 6 months or 6 months or more after that initial offer. But they do have that residual right to request in the future. And then there's another question here around the Fair Work Commission and template letters available to send to casuals. I'm not sure what they have on their website. They might have templates on there. But yeah, it's worth having a look. It's also something we provide to our clients as well, just around the overall comprehensive advice and assistance on engaging employees and particularly casual employees and these requirements as well. So look, I think that's all of the questions. Unless anyone has any further questions, feel free to type those in now, either in the chat or in the Q&A section. Happy to cover off anything further. But it doesn't look like we're going to get any more. So I think that's probably a wrap. Just want to say thank you for everyone for attending. Hopefully you've gotten something out of this session today. Hopefully it's not anything else. It's just a reminder of these, the amendment and the end of this transition period and the potential requirements that you may have. If you'd like further information, feel free to check out our website. It's myhr.works.pu. You can go to that website. You can further information around casual employment and casual conversion, or you can get further information about various other things to do with employment and HR. Thank you very much.